Welcome, everyone. Thank you for tuning in to our webinar. Lots of great information today. We have a fantastic presenter. Lauren will talk about estate planning, go through the essential documents required for an effective estate plan, and talk about a few common pitfalls, things that can trip people up, and more importantly, how to avoid those. But before we get into all of that, we'll do a quick introduction. Kevin and I will talk about the firm. We'll also go through our team. An important reminder for everyone tuning in, we want some interaction. If you have questions, please let us know. You can type it into the comment section. So whether you're on Facebook or you're on YouTube, you can add it to the comment section. We can see that, and we'll try to answer the question or pass it along to Lauren so you can get some information you find of value. And that's the whole goal tonight, is to get some information you find of value. We'll tackle a few of those questions as we go, and we'll also have some time allotted at the end for a more in-depth Q&A session. So lots of opportunity there to ask some questions. But Kevin, let's dive in. Introduction to ourselves as well as the firm involved.
Yeah, as we've mentioned, I'm Kevin, that's Clinton. We are the Becker and Becker Wealth Management. We are part of Canaccord Genuity Wealth Management, and Canaccord Genuity is a global corporation. We've been entrusted with roughly $95 billion of clients' assets globally. We have offices in Canada, the UK and Europe, Australia, and we also have offices in the United States. And we do all sorts of different investment advising as well as financial planning and cover the whole wealth management stream. As well, we are a member of the CIPF, which is the Canadian Investors Protection Fund. This is the insurance that we have on your accounts. It is also the same insurance that is used by the big bank firms. And this helps to provide clients with peace of mind in regards to their portfolios moving forward.
Absolutely. And a reminder for those just tuning in, Lauren will be on in just a moment to talk about estate planning and cover some of the common pitfalls. And you can use the comment section to ask any of your questions, whether you're on Facebook or YouTube, type them in the comment section. We can see those and we can pass those questions along. Quick introduction to our team. You can see all of our smiley faces there with 5 full-time members. We do have part-time staff in addition to the full-time members. And the driving force of our team, our motto, if you will, it is commitment, clarity, and confidence. And I know I go through this every time, but it's important. We like to repeat it. And for us, commitment, it's all about communication. You need to hear from us. We need to keep those lines of communication open. And it's a two-way street. We want to keep you informed of what's going on in the markets with your financial plan. We also want to know from you if there have been any changes, anything we should be addressing. If we do our job there, high level of commitment should lead to clarity. Clarity in the goals, clarity in the objectives, all the cards on the table when it comes to fees, rates of return. So a high level of commitment, high level of clarity, the end result, confidence. I want you to have confidence in the team, confidence in your finances, most importantly, some peace of mind and confidence with your financial plan. And I mentioned the financial plan. It's a big part of what we do. We have a process, quirky title. We call it financial architecture, but it's appropriate. And Kevin, you might say Adam Buss on our team is the lead architect when it comes to financial planning.
I probably would. Yes, I would.
He is the wealth and estate planning professional on the team. He helps out driving those financial plans. And the idea, the reason we call it financial architecture, if you're going to be building a new house, lots of decisions need to be made. The first one, probably not going to be the paint color of the kitchen. Lots that has to happen before you get to there. Same thing in the financial world. You got to make sure the building blocks are taken care of before you worry about the interior of your financial house. Those building blocks, it's the estate plan, it's your insurance, the frame, retirement planning, tax planning. What we do with those pieces will influence the interior, which are the investments. We have to make sure all those pieces are taken care of. And tonight, we're going to be talking about that foundation, going through some of the estate planning essentials.
Yeah, and most of you didn't tune in to hear just Clint and I speak. We normally will do that more on a financial basis. But what I want to do is I want to introduce you to our keynote speaker tonight, which is Lauren Vrsnik. She is an associate lawyer at Taylor McCaffrey, where she practices primarily in the areas of business law, taxation law, and estate planning. And tonight, Lauren's going to go over, or we'll cover the essential documents of an effective estate plan, as well as she's going to review some of the common pitfalls and how to avoid them. So without any further ado, I'd like to present Lauren Vrsnik.
And there we are. Lauren, Hello. Did we get the last name correctly?
Yes, great job.
We were worried there for a bit.
No, you did great. Thank you very much for having me.
No problem. I'll let you pull up your presentation here. We'll get you all set up, and then we'll jump into the estate plan. Thanks. And again, for those of you just tuning in, Lauren is pulling up her presentation here. I think we have it on the screen now, and we'll get out of the way so she can provide some estate planning tips. And a reminder, if you do have questions, ask them in the comments section. We'll do our best to address those as we go. So I'll hand it off to you here, Lauren.
Thank you very much. Okay. Here we go. So as Kevin and Clinton mentioned, I will be giving a high-level overview of some basics relating to estate planning. There's two parts to the presentation. The first one relates to things that you're going to need to be aware of during your lifetime, and some documents that basically all adults should consider, those being a power of attorney, a healthcare directive, and a last will and testament. The last will and testament could probably be in either of these headings. It is a document that is drafted during your lifetime, but it does not come into effect until after one's passing. The next part of the presentation will be talking about what happens after you die, where the last will and testament comes into play, and your executors or administrators will be applying for probate or administration of your estate. So first thing, we will talk about the power of attorney. The power of attorney is a legal document where a person who is referred to as the donor is giving authority to another person who is referred to as the attorney to make decisions regarding some or all of the donor's financial and legal affairs. So the important parts are, this is a document that's only in effect during the donor's lifetime. It's a document that allows someone else, the attorney, to step into the shoes of the donor and essentially do anything that the donor would be able to do themselves, but specifically relating only to financial and legal matters. There are three types of power of attorneys. The first one being an immediate power of attorney, which comes into effect the moment that it's signed. The second would be a springing power of attorney, which would come into effect at some later designated time or date. So after a certain event were to occur or a certain date is reached, then the attorney, their powers would kick in at that point. And the third type would be a specific purpose power of attorney, or a limited power of attorney, which would give the attorney the ability to do only something specific that specified in the document. All three of those types of documents can be what we call enduring or not. So what that means is, if it's an enduring power of attorney, it would include a clause that states that the power of attorney continues to be in force even following the donor's mental incapacity. So that type of document is quite a powerful document. So it is required that there's certain execution requirements that must be followed when those documents are being signed. And so they need to be properly witnessed by, there's a list of people that can properly witness an enduring power of attorney, lawyers, notaries, judge, I believe an RCMP officer. There's a couple others, but it will need to be witnessed properly in order for it to be effective. Some other things that need to happen in order for an enduring power of attorney to be effective is that the donor must be mentally competent. The power of attorney must be in writing. And as I mentioned, it must be signed and witnessed properly. So if there is no power of attorney, what has to happen, and the donor or the person who would have entered into the power of attorney is unable to manage their affairs and needs someone to step in to manage affairs for them, then what happens is a private committeeship application will have to be brought to the court in order for a committeeship order, which appoints someone to act for that individual. So the issue there is that a committeeship order is more expensive than having drafted a power of attorney in the first place, and it takes a lot more time. So the way the way power of attorney is drafted is we would basically give your attorney as many powers as possible, so that any kind of situation that comes up, they would be able to act for you if you were unable to. So some things to consider as you are giving your lawyer instructions for your power of attorney is number one, who you will name as your attorney. You can name one individual or multiple individuals to either act jointly or successively. As a general rule, it's a good idea to have more than one attorney named, since this individual might become unavailable or unwilling or unable to act. That being said, you also don't want to have too many attorneys, because that also could cause problems, especially if the individuals that you've named have different beliefs or philosophies concerning financial issues. So good rule of thumb is you can name one person and have someone named to act if that first individual can't act, or if you name 2 or maybe 3 people that you want to act together, that works too. If you've named a number of individuals jointly and it's an even number where there's no majority as to who. Oh, Kevin, did you want me to finish or you want to step in? Sorry.
No, you can finish first before I get to it. You
Okay.
might answer it in that time.
Okay, so if you've got a number of people named and they don't agree on what kind of decision they want to make, the law states that the person whose name shows up first in the document is the person who will have final say. But that is on the assumption that you haven't provided in that document how you might like tiebreakers to be decided, or whether you want a third party or someone else to make the tie-breaking decision.
Yeah, so that's somewhat along the lines of the question I was looking. So can you have a joint power of attorney where both parties have to agree on everything, or is it an either or situation, or can you just set it up both ways?
However you like, yes. You can have multiple individuals acting jointly, in which case all 3 individuals have to be on the same page and all 3 have to act together in order to take steps. If it is, so your power of attorney can then indicate how decisions are to be made between the 3 of them, whether it needs to be an all, like a majority decision or an all or nothing decision. And then if the power of attorney is silent on that, then the legislation steps in, which says that it will be a majority decision first, unless we have an even number, in which case the individual whose name shows up first has the final say.
Okay, perfect. That answers exactly what I was looking for.
Great. So it's a matter of drafting, and it's a matter of making sure, it's something that your lawyer will walk through with you to kind of consider all the possible situations and how the power of attorney should be properly drafted to in considering all those possible situations. Okay, next thing, should the attorney be paid? So this is something else that you'll want to consider when you are preparing your power of attorney or having your power of attorney prepared. If the donor wishes that the attorney be paid for acting as their power of attorney, there should be a provision included in the document to allow for that, because it is arguable that if the document does not contain a provision providing that the attorney be paid, that they cannot charge for their service. So that is something that you'll want to make sure is in there if it is something that you want to happen. The next thing would be to think about how broad or how limited you might want the powers that you're giving to your attorney to be. So this is completely up to you. If there's certain things you want your attorney to be able to do or not do, then we would revise and tailor the power of attorney to your requests. As a rule, we would want to provide enough authority to your attorney to make sure that they are able to look after your affairs once you're unable to do so. But again, this is an issue that you would discuss with your lawyer to see what would be the appropriate amount of power to give the person that you're naming. Okay, when it comes to the homestead, what we typically see is someone naming their spouse or common law partner as their attorney to act for them if they're unable to. But when it comes to the purposes of dealing with the homestead, so that would be selling basically the marital home where you and your spouse are living, your spouse cannot consent to the sale of that property on your behalf. So your spouse cannot act as your power of attorney to sell your homestead or your primary residence where the two of you are living. And so you will need to name somebody else in your attorney to act for you for the purposes of dealing with the homestead. And so typically if you had your primary attorney that you named, and if that person was your spouse, they were unable to act or unwilling to act, you'd have someone, a second attorney named as your alternate attorney. And then we would say, for the purposes of dealing with the homestead, it's the alternate attorney who will act as power of attorney for those circumstances, notwithstanding that the spouse or the primary attorney is attorney for generally all other purposes. But it is important to have in there because you might think that naming your spouse as your attorney would allow them to sign real estate documents for you if needed, but that is not the case when it comes to the homestead. A couple risks that could come up if you do not have a power of attorney put in place is that if you do become incapable of managing your affairs, then at that point you will not be able to decide who manages them for you. Because like I said earlier, you do need to have capacity to sign a power of attorney. And so if you lose capacity and someone needs to step in, then it would be up to your family or whoever would make the court application for a committeeship order, and the court would ultimately decide. That another issue would be that if that is the process, there will be a period of time where there is no one who's able to take care of your affairs. So bills might not be getting paid, no monies are being received until such time as you receive that order from the court. And again, that committeeship order will be a lot more costly than if you had signed a power of attorney earlier when you had capacity. Okay, so now we'll talk about a healthcare directive. So these are also sometimes called living wills. This document is one where typically you are naming a person who we call your proxy, who would make healthcare decisions on your behalf. So this is different from the power of attorney because the power of attorney deals with legal and financial matters, and the healthcare directive deals with only healthcare decisions. The healthcare directive will only take effect when or if you are unable, if you don't have the capacity to make medical decisions yourself, or if you're unable to communicate your medical decisions. So at law, there's no person who has authority to make medical decisions for you if you're not able to make them yourself, not even your spouse, your kids, your parents. So if there is no healthcare directive and you're not able to make medical decisions or answer questions that your physicians or your doctors are asking of you, what happens is they'll typically go to the family and whoever is around. And so long as everyone is on the same page about what it is they'd like, how they would like your medical care handled, then that's fine. But the issue comes up where two people are at odds about what course of treatment they might want your physicians to be taking. And so at that point, if there's no ability to agree, typically, I believe what would happen is your doctors would take the more conservative route. But if you did have this healthcare directive, then they would have somebody whose authority they could follow in terms of making decisions for you. So again, this is a document that needs to be in writing, signed and dated. The person making the healthcare directive needs to be over the age of 18 and mentally capable of giving informed consent to treatment at the time that they make it. And it must be brought to the attention of your healthcare providers. So there's no requirement that a person has to inquire into the existence of a directive before taking instructions from somebody. So it is important to communicate to your proxy, the person you've named, your family members, and your physicians if this is a document that you have created.
Good. Well, 2 quick points here, Lauren. And first, for the folks watching, again, you can type into the comments section if you do have questions. We can definitely get those to Lauren so you can get an answer. But just a point of clarification. So 2 items. First one has to do with the power of attorney, because this is a common issue that we see. So I think it's a common pitfall that you can help people avoid. Has to do with people naming their spouse as power of attorney and then thinking that's it. And that's all they need to do. And what you're saying on your prior slide is that individual, if it's your spouse, they can't actually sell the homestead. So you need to have an alternate, or should have an alternate in that case, so that if that comes up, they would still be able to address that situation. Is that correct?
That is correct, yes.
Okay. So a pitfall we see that a lawyer with a power of attorney could certainly handle having that alternate. And then as it relates to the healthcare directive, often we see folks, they go to the Government of Manitoba website, the gov.mb.ca, or whatever province they're a part of. And the Government of Manitoba, at least, they do have a form on there that you can fill in to act as your power of attorney. Is there, or probably not power of attorney, healthcare directive? Is there a difference between going to see a lawyer or just filling in that form online? Like, what are the pros? What are the cons? What are your thoughts on that?
That's a good question. And to be honest with you, I have not taken a look at that form in some time. So I would need to refresh my memory of exactly what it says. I do know that it exists. I suspect that it generally, I really should take a look before I speak about this, but I suspect that that document is more a general healthcare directive, which is something that we would provide as well, which basically names someone to be your proxy, but doesn't set out specific requirements or requests that you might have about your care. So that is another point that I wanted to bring up, is there's 2 ways to draft a healthcare directive. One of them being a more general, all-encompassing, where you name your proxy and you state that you have communicated your wishes to your proxy, and that they have authority to communicate those wishes to your physicians, and that if you haven't communicated wishes about something, that they can use their discretion and would be able to make decisions based on what they believe you would want. Another way to do it is to specifically write in there what type of care you may or may not want to receive, depending on the circumstances. And with that, it's certainly possible, and we do that often. Unless you have something very specific or important that you want in there, we would tend to recommend going the general route, just because if it's not drafted exactly how you want it, there could be confusion when it comes time to following those instructions. Or I shouldn't say not how you want it, because we will draft it exactly how you want it. But if there's some confusion with maybe the type of care that needs to be decided on and what's written word for word in the healthcare directive, that is an issue that we would want to avoid. And the other thing is that when you're putting your specific wishes in there, you're most of the time not taking into consideration medical advice that your family might be getting about you at the time that the decision needs to be made, which may influence your decision or what you had thought you might want when you wrote those instructions. So sorry, I think I got a little bit off course, but going back to the government document, that is certainly sufficient. But if there were something specific, or if there were additional points that we would want to include, the document that we provide is definitely has a bit more in it, and it considers a few more things that I think that government document doesn't necessarily consider.
Yeah, so the government document meant as easy access, kind of a cover-all, very general form. But if folks want to go in more detail, more specific, that's when they'd want to see a lawyer to make sure it's done according to their wishes, right?
Yes.
Okay. Well, and people keep the questions coming, and we'll let you get back to the presentation, Lauren.
Thank you. Okay, the other thing about the healthcare directive is that it is a document that will only take effect once you don't have capacity to make decisions. Otherwise, so long as you can communicate your choices and you have capacity to make them, you're the only person that can make medical choices for yourself. Okay. Oh, you know what? I did just want to be clear about the healthcare directive, that the most important part about it is to discuss what your wishes are with your family or the person that you've named as appropriate, and to make sure that you let people know that you have it, and to discuss the choices or the what you've put on there with your doctors. Okay, so now we will talk about a last will and testament. So what this document is, I'm sure most of you are familiar. It sets out what happens to one's property after their death. So this document does not take effect until the person who wrote it dies. And this document can be revoked or changed at any time during the testator's life, so long as as the testator has capacity to do so. So let me back up just a second. The terms that are used are testator, meaning the person who wrote the will and the person that the deceased once the will comes into effect. And the testator appoints one or more people or a trust company to be the executor. And the executor is the person charged with following the instructions in the will. And we'll talk a little bit more later what kind of roles or duties an executor has in administering an estate. So one of the most important things when it comes to the will is that there are specific execution requirements set out in the Wills Act. And so what those are is that the will must be in writing. The will must be signed in the presence of 2 witnesses. The witnesses cannot be beneficiaries named in the will, nor can they be the spouse or common law partner of a beneficiary named in the will. So and also the will must be signed by the testator at the end. So there's a few things, like the witnessing requirement is something that a lot of people don't usually know, and where people can get tripped up if they're trying to draft a will on their own. Okay, so I should go in order here. The will does not take effect until the testator dies. So as I mentioned, they can make changes as many times as they like, provided they have capacity. And capacity to change or create a will is something that is determined by a lawyer, not a doctor. So you may not have capacity for some things, but you may still have capacity to enter into a will. So there are certain legal tests that your lawyer would be considering and looking at when determining whether they think you have capacity to enter into a will or to change a will that had been made. A holograph will is another type of will that can be made and is valid. So in the Wills Act, it states the requirements for a valid will, and then it also says that a will would still be valid if it is signed completely in the handwriting of the testator and signed at the end, even if the proper witnessing requirements were not followed. So that's what we call a holograph will, where an individual would have to physically handwrite the entire page. This is my last will and testament. This is who I want to be executor. This is what I would like to happen with my assets. And then they sign it at the bottom. And so that will can still be valid. It's not necessarily recommended because there are a number of things that may be missing or some items that might be contradictory in there if you're not having assistance from a professional in drafting your will. But I will mention that it is still a valid will. Did you have a
Perfect.
question?
I've got a quick question for you. More
Sure.
of it relates to some of the stuff we've just talked about before, but
Okay.
in regard to a sort of a POA health directive, who decides whether you have capacity or not?
That would be your lawyer. So sorry for when are you talking about when you're entering into the document or when the document is being used?
When the document's being used.
Being used. So with the power of attorney, if it's an enduring and if it's an immediate enduring power of attorney, that document becomes effective the moment it is signed. So if your lawyer determines that you have capacity to sign it, that document will take effect as soon as you've signed it. Because it endures beyond any mental incapacity, there really isn't a person who has to decide when that incapacity takes place, because that document can be used before, after, at any time. The issue arises when you have a power of attorney that states this power of attorney only comes into effect upon my mental incapacity. Then we're kind of back at square one, because at that point, you may need to get a court order again to determine whether or not you have capacity, because someone may suggest, your family member may say, oh, they don't have capacity, I need to start using this power of attorney. But you might disagree and you say, no, I do have capacity still, you can't use this power of attorney yet. And so at that point, a committeeship order or an order determining capacity would need to be obtained. And the point of the power of attorney may not have been realized if that's the way that it was drafted, or that's the way that you decided to do it. With the healthcare directive, again, your lawyer will determine when you're signing whether you have capacity to enter into it, but your doctors will be the ones determining whether or not you should be the one making your healthcare decisions, or whether your proxy would step in.
Yeah, and in regard to the healthcare directive, now, what are the ramifications if the family decides they don't want to follow the terms of the healthcare directive or something along those lines? Is there anything that can be done, or?
That's a good question. The doctors would have to follow the wishes of the proxy named in the healthcare directive. The proxy is required to follow the terms of the healthcare directive. So they do have a duty to follow the requirements of the person who made the healthcare directive. Yep. Practically speaking, if they don't, I suppose that would depend on what happened, and whether the person who signed the healthcare directive, was able to, whether they would be able to or want to make a claim against that person if there was any losses suffered or damages at that point.
Okay, good. Thank you.
Thank you. Okay, so I think I just finished with the holograph will. The next thing that I will talk about is a will kit. So a will kit is something that you'll find typically online. And so it's kind of a fill in the blanks type document where someone has prepared a basic standard will where you would kind of fill in the names and fill in your wishes and how you'd like your gifts to be made. And then you sign at the end. So the issue with the will kit is that it is neither a properly executed will most times, nor is it a holograph will, because if you've printed this document and you've handwritten in the names of who you want to be executor, who are the beneficiaries, that's technically considered a will that has been changed. So it's not completely typed out in one go, and you've kind of made changes to it. And most times those will kits are not properly executed either. So there's usually the individual who's signing it didn't know that they needed to have two witnesses who also sign, and that those witnesses cannot be beneficiaries named. So But then on the flip side, it's not a holograph will because it's not completely in the handwriting of the testator. So it is still possible that it can be saved. There is a section in the Wills Act that allows your executor to apply to the court to basically make any fixes to the will that might not or that might need to be done in order for it to be a valid will. And so they'll ask the court to confirm the validity of the will, even though it may not conform with all the requirements of the Wills Act. So the best case scenario, if that is what's happening, is that the will kit that you filled out is clear, it's unambiguous, there's no nothing contradictory, nothing that doesn't make sense, and everyone is on the same page that they believe that that is a valid will and that's the will that they would like to have followed, and so it can be validated by the court for sure. Worst case scenario is that if the will kit is ambiguous and their beneficiaries are at odds with each other, this can result in lengthy and expensive litigation, because now you have two groups who are basically, one are saying this is what this will means, this is how it should be followed, and another group saying something different. So it is best to consult a lawyer when it comes to having your will drafted so that they can make sure that your will is drafted in accordance with the requirements of the Wills Act. Something else to consider is whether you would like your executor to collect fees for acting as your executor. So this is something that a lot of people think they need to put in their will. An executor is allowed to collect fees whether or not there is a clause in the will that explicitly suggests that they should. If you really want your executor to take a fee, a good idea, something that we often suggest, is to make a specific gift to your executor, provided that they act as your executor. So because again, even if they know that they can take a fee, sometimes they don't, and sometimes you really want them to. So you can make a gift to your executor saying, I give so-and-so this amount of money, provided that they acted as my executor. Something else in your will be a clause regarding the guardianship of your children if they are minors when you pass away. This is, at the end of the day, it's the court that makes the final order. But if it is written in your will who you would like to be guardian for your children, then that is something that the court will strongly take into consideration when making that order. Okay, so some common issues that come up with will drafting, or some common topics that need to be discussed with the person drafting the will, has to do, number one, with joint accounts or joint assets. So if you have joint accounts or joint assets, what happens when you die is that the other person who's joint on that account or on that property, so for example, your home, receives that property by right of survivorship, and they become the sole owner of that asset. So when you have two joint owners, it's like you have two 100% owners, and when one dies, the other 100% owner remains 100% owner. And so that asset does not fall into your estate and is not distributed according to your will. There is an exception or something to make sure you're thinking about when it comes to joint accounts with a child or with a parent, because if a parent has a joint account with an adult child, there's something, a legal situation called the presumption of resulting trust. And so rather than it being an assumption that that joint account was meant to be a gift to the survivor, there's actually a presumption that that surviving adult child is holding that account in trust for the estate. Because it's very common that an elderly person may open or bring on one of their adult children as a joint holder of their bank accounts to practically help with day-to-day stuff, but they aren't actually necessarily gifting that account to the child. So the presumption is that that account is being held by the child in trust for the estate and is to be distributed in accordance with the estate. If that is not the case, and the joint account is actually meant to be a gift to the other individual, then we would want to make sure that that was clear, either in the will or sometimes with the bank, there might be notes that that was something that was discussed and that is the intention on the account. But in any case, that is definitely something to consider, because the only time where it will be assumed that it was a gift is when it's a joint asset with a minor child. Okay, another thing to consider is any unintentional unequal division of assets. So when you're drafting your will, you may the gifts you might make, you might say, oh, I'm going to give my RRSP worth $100,000 to my daughter, and I will gift no, you know what? Let me change that example. My $500,000 RRSP to my daughter and my $500,000 house to my son. And that way they both benefit equally, maybe at the time, but there are circumstances where those values may change. And so you want to make sure that if the intention is to create equal gifts, that it's drafted in such a way that your will do so. I think I need to speed up a little bit. Another important thing to think about are beneficiary designations. So with your registered plans and your life insurance, you will have named a beneficiary for those plans. The legislation allows that you can name someone else or a new beneficiary in your will. And so if you want to do that, you can. The best practice would just be to make sure that the beneficiaries that you've named on those plans are the beneficiaries that you intend to benefit. And so again, like a joint asset, those funds would flow outside of your estate directly to that beneficiary and would not form part of your estate. Some things that can bring up issues when it comes to administering an estate would be whether or not the testator had capacity when they were signing the will or making any changes, or whether there was any undue influence coming from a family member at the time that they were signing. So your lawyer will want to be sure that that's not the case at the time of signing. There is legislation that allows for dependents to challenge the will if they were not properly provided for. So if there are individuals, there's a list of individuals who can apply. And so that might be, for example, a spouse or a child or grandchild who is financially dependent on the testator. And then the testator did not provide anything for that person in their will. In certain circumstances, they can apply to basically receive support from the estate. And then again, execution issues, we talked about that before, so I won't get into it again. Once you have drafted your will, it is important to review when circumstances change in your life. So if there is a breakdown of relationships or new relationships, you may realize that you want to change what you've put in your will. And like I said, you can certainly make those changes as many times as you like, provided you have capacity. Okay, so now we'll talk quickly about probate. What is it? It is the process of submitting the deceased's last will and testament to the Court of Queen's Bench in order to prove its validity and to have the court state that this is a valid will and the person named as executor does have power over the deceased's estate. So the court will then issue a grant of probate, which is a document that you take, and once you have the grant of probate, then you can use it to start administering the estate.
Perfect. We have a couple of questions coming in, which is fantastic. And I know we told everyone roughly an hour, 6:30 to 7:30. We want to try to respect that. So I'll ask the first question here, and it has to do going back a topic or two, but it's asking, do witnesses need to initial each page of a will and get copies of said will?
Yes. So the proper way to execute the will would be to have the testator and both witnesses initial the bottom. Basically, what we typically do is we do an initial at the bottom of each page of the will. And so all three individuals would do that. Then the testator needs to sign their name at the end of the will. And the two witnesses would sign their name as well. No, the witnesses do not need to receive a copy. There's no requirement of that. And in fact, the will can be kept at the lawyer's office, which is typical in storage. We would always provide a copy to the testator so they can have it in case they ever wanted to take a look, but there's no requirement for anyone to have a copy.
Okay, well, I appreciate that. We do have 4 or 5 more questions here, but I know you have a few more topics. So perhaps in the essence of time, you can hit kind of the high levels of those additional topics in the next kind of 5 or 6 minutes, and then we can open up for Q&A because we have a bit of a backlog here of questions, and I want to make sure everyone gets an answer.
Absolutely.
All right, so I'll let you get to it to get through those last few topics.
Thank you. Okay, so when is probate required? So again, what we're doing is we're taking the will, we're submitting it to the court, and we're saying this is the last will and testament of the deceased. Please validate it. And so then the court gives us back the grant of probate. Once we have the grant of probate, we can start administering the estate. And so there are certain situations or certain things that you need to do where you need the grant of probate and certain things where you don't need it. So if there is real property held in the name of the deceased that is going to need to be transferred into the name of the estate and eventually transferred to a beneficiary, you need a grant of probate. The Land Titles Office requires that. If the estate is designated as a beneficiary of pension, insurance, or investment funds, the account administrators will also require the grant of probate before they release those funds. And also, if banks or credit unions, they can also request a grant of probate before they will release funds to the estate, but they don't have to. So some banks, I know, have a threshold of, depending on how much they're holding for that member, whether they're going to require that you provide them with the grant of probate or simply a death certificate or something like that. When probate may not be needed would be if all of the assets are held jointly and the deceased would be the first of the joint holders to die, because in that case, all those assets would be transferred straight over to the survivor. And also if all the assets have a designated beneficiary, then we don't need the grant of probate as well. Okay, if we aren't receiving a grant of probate, we are going to need to apply for letters of administration. So this is a situation where the deceased does not have a will. And so we have to go by the terms of the Intestate Succession Act, which sets out, number 1, who can apply to administer the estate, and number 2, what happens with the estate. And so there is a specific set of instructions of where the assets will go. So typically everything would go first to the spouse. If there is no spouse, everything would go to the children. If there's no children, it would go to the parents. And there's a whole laundry list of order of where your assets will go if you did not have a will. The issue with that is you obviously do not get to decide for yourself where your assets will go when you die. And another issue is that the administrator may need to post a bond to the court before the court will grant letters of administration to that person. So next, the typical steps to administer an estate. So this would be whether there is a will or not. The family would want to locate and review the will if it's available. They can then make funeral arrangements right away. We don't need the grant of probate to do that. You'll likely want to retain a solicitor for the estate so that they can assist you with applying for the grant or administration from the court. Form 74AA is available online, and it sets out how much lawyers can charge to help with estate administration. So there's a set tariff that basically it depends on the value of the assets held in the estate, and then there's a percentage that can be charged for legal fees for a basic estate administration. If the lawyers are required to do things kind of beyond what would be considered basic assistance, then they can charge above that tariff. You'll want to take an inventory, or you'll need to take an inventory of all of the assets. And so part of that would be setting up an estate bank account, transferring funds into the account. You'll pay bills, you'll collect any income coming in, and ascertain if there's any debts or liabilities of the deceased. You will be responsible for notifying the beneficiaries of their interest, so the beneficiaries named in the will, or beneficiaries pursuant to the Intestate Succession Act. Then you will apply for and receive either probate or administration if it's necessary. You'd be required to prepare and file tax returns, so you typically retain an accountant to assist with that. If there's any potential claims against the estate, you will need to be aware of those. And so what we would typically do is post a notice to creditors in the paper. And what that does is it asks any credit, it provides notice to creditors so that they can give notice to the estate of any claims that they might have had against the deceased. And what that does is it protects the executors and the beneficiaries from being liable for any of those claims if the creditors did not come forward. Because if they do not set out the notice, there is a chance that the beneficiaries or the executor could become liable for any claims against the estate if they did not take efforts to figure out what they were and settle them. Then the executor or the administrator will need to prepare the estate accounts for approval of the beneficiaries or the court. So they need to set out all the assets, basically everything that they brought in, anything that they paid out of the estate. All of the beneficiaries have to consent to the final basically disbursement of the estate before that can take place. And if the beneficiaries do not consent, then the executor goes to the court and asks the court to review, and it's called passing accounts. And so they will confirm whether the estate was managed appropriately or as it was supposed to be.
I'll wait till you finished your points if you got any more left. Or
yeah, well, last thing would be that the executor needs to obtain releases from all the beneficiaries, basically confirming any fees charged, that they agree that all the assets have been collected, and how the estate was going to be distributed to the beneficiaries. And then once those are all obtained, then they can distribute the estate in accordance with the will.
Wonderful. I mean, that's been excellent. Great news that I didn't know about beforehand. One of the questions I have here is, it's going to go over, now that we've covered the entire sort of estate scenario that we've gotten here,
Yeah.
What signatures would be required on a memorandum or a codicil if you were adding that to the will? Is it just the tester, or is there more than that that's required?
No, that's a great question. So it's any kind of codicil, which is an addition or change, a document making a change to the original will without redoing the will. So you can just kind of add another page that says, I want to change this about what's in the will. Mm-hmm. And that codicil needs to be executed following the same requirements as with the will. So we need the same witnesses, basically the same. Similarly, though, the codicil can be done by way of a holograph codicil. So it can be done completely in the handwriting of the testator and signed at the end also. And that would also be valid.
Okay, that's perfect. Now, in regard to, say, an executor or a POA, you've mentioned there's fees. What would be a typical executor or POA fee that they would receive?
Well, that's a tough question. Some would suggest a percentage of the estate would be mm-hmm. appropriate, and that could be, in the 1%, 2%, 3%, something like that. But what might be more appropriate would be a fee based on how much effort was required on the part of the executor. And so estate administration can differ significantly depending on how complicated it is or whether there's any roadblocks that come up. And so one executor, if you have two estates that are the same value, one executor may have put in a lot more work than the other. And so that is something else that could be considered. And there are guidelines of what kind of fee an executor should take. And it's essentially, there's a lot of right answers. But at the end of the day, it does need to be approved by the beneficiaries just to make sure that it was an appropriate amount.
Okay. I have one last question on that sort of executor scenario is, obviously executors can collect a fee now. That's a benefit for them. Is there any liabilities to being an executor?
Yes. So you, as executor, you will need to ensure that one big one is when it comes to taxes. And so we always recommend that the executor, number one, receive advice from an accountant when they are filing the estate tax returns. And number two is obtaining a clearance certificate from Canada Revenue Agency, basically requesting that CRA confirm whether there's any outstanding tax arrears or anything like that. Once we receive the certificate, the executor can be confident that there aren't any outstanding debts owing to CRA and can distribute appropriately.
Wonderful. Thank you.
Good. We have a couple more questions for you here, Lauren, and perhaps I think you have one more slide that has your contact info on there. Maybe you want to switch to that one, just so folks, if they have a more detailed question or need to set up an appointment to go through a specific scenario, they can certainly do that and reach out to you, Lauren. But I had a question here from Margaret via YouTube asking about insurance. I think we can tackle that one because we do a lot of financial planning for folks. Adam Buss, our financial planner, often tackles the insurance. Margaret was asking the best type of insurance. It will vary with each situation, but generally you probably want joint last to die insurance. Term insurance wouldn't be as applicable because it might not be there when it is needed, but generally joint last to die whole life policies would be applicable for covering the taxes on an estate. But more detailed questions, I'd defer to Adam. If you have those, Margaret, we can help you out. Also had one here for you, Lauren, from Cheryl. A specific scenario, wondering if an individual's in a long-term care home and there's cost associated with that, if the financial cost of the long-term health care can supersede the powers of the POA to use the funds for other ways. So the power of attorney can use the funds, maybe those care costs there, but is there kind of a ranking? Do they have to use it for the long-term care facility before they use it for other needs of the individual?
So with the power of attorney, it generally doesn't, unless it's a specific power of attorney, it generally does not specify what you can and can't do with the donor's money. Mm-hmm. And so generally, the attorney has a fiduciary duty to the donor to manage their affairs in a way that is in the best interests of the donor. And so if it would be in their best interests that those funds be used to pay for their care, then generally that would be considered to be in their best interests.
Okay. So there's a bit of flexibility there, but a fiduciary duty to make sure it's in the best interest of the individual. And one here from Diane on YouTube asking if the beneficiary, I assume they mean here of an estate, if the beneficiary can also be the executor.
Yes, absolutely.
Okay, so it's not
not an either.
It doesn't have to be defined. They can be both roles.
That's right. So it's you're naming someone to be your executor, and that can be whoever you choose, and then whoever you are giving gifts to, they become beneficiaries. And so if you're going to give a gift to an executor, they would by definition be a beneficiary under your will.
Okay, all good questions. If you have more, folks, feel free to type them in the comments section. Well, we have Lauren on the line. We may as well ask a few more questions. And if people need to get a hold of you, Lauren, I assume the contact information on the screen is the best way to do so?
Yes, absolutely. Email or phone call. I'm available and happy to answer any questions.
So if you do have a more specific scenario, feel free to reach out to Lauren. And if you have a question for myself or for Kevin, now we're not lawyers, so we can't go as in depth about estate planning items, but for all the other financial planning needs, you can always visit chatwithclintonandkevin.com. We'd be happy to hear from you, happy to help out. And I'm noticing no more comments coming in here, so I think we've covered it all. Lauren, any final comments, anything you'd like to say before we sign off?
No, but thank you very much for having me. This was great. I appreciate it. And again, any questions, feel free to reach out to either myself or to any of the lawyers here at Taylor McCaffrey. They're all excellent lawyers and professionals, and they'll each be able to help you out depending on what your circumstances are or what kind of questions you have.
Well, we really appreciate that you provided us with all this great information tonight and provided the webinar guests that we've had as well. Thank you very much for helping us out with this estate planning topic. It's always nice to hear from a lawyer as to how these things work, because as Clint mentioned, we are not lawyers, so generalities for us are pretty much there. But we would recommend that if you contact anybody, please get in touch with Lauren, or if you get through to us, we can provide your names to Lauren and have her contact you that way if it makes it easier.
I've got to jump in here quickly with the buzzer beater, Kevin. Right before the bell, we had one last question here. So hold on just one more moment. Lauren, Sandy via Facebook asked, and this could be a big topic, but if you could touch on it, how does one set up a trust company as an executor?
Yep. So basically you would, it's as simple as naming the trust company as executor in your will. But that being said, the trust company may have certain documents that they require you also sign as part of naming them as trust company. One of them being possibly they may want you to agree to their fee and to sign to say, this is, I understand what their fees are going to be and I agree to it. And I know what their fees are when I name them as being my executor, so that no one can come back and say that you didn't know how expensive that was going to be, or yeah, so it's as simple as naming them in the will, and then following any requirements that they may have when it comes to naming them.
Okay, appreciate that. So I think that was it for questions. Thank you everyone for tuning in. Thank you, Lauren, for providing all the information. And we look to set up another type of event in the near future. So please, everyone, stay tuned. We'll be back again very soon. Take care.
Take care.